Hi guys, David Campanile here, owner of Campanile Law, located in the great state of New Jersey. We handle estate planning, we handle probate. Today I want to talk to you guys about a situation that a client actually came up to me after they created their revocable trust and basically was trying to figure out how to put things into their trust. So, as always, before I get started, if you would like to schedule a free strategy session with me, contact me at njestateattorney.com. I don't know why I just changed my voice there. That is, wow. All right. Anyway, let's get to it, shall we? So, a client came in. They had a revocable trust. But the attorney that they had kind of just gave them the trust documents, didn't give them any instructions, and sent them on their merry way. And in the beginning, that's great. You know, you're excited you have this trust document, and you know, you're not really thinking about how do I put things in here. So let's talk about it. So, depending on how the trust document's drafted, and remember, a trust document is similar to a will, okay? It's something that you always want to keep reading over, reviewing, revising, altering, because assets are going to change, bank accounts things are always going to change. So what is the one constant we know in life? That is change. So this is a document that you should be reviewing once a year. I know with my clients, I offer them a once a year review on wills, trusts, and their estate plan just to make sure everything is the status quo. So, back to it. Reading through the documents, I go, okay, do you have a trust ID number that you have to go file with the IRS? No. Okay. Very simple. Your attorney can do it. You can do it yourself. Is you go online, go to irs.gov, and you create a revocable trust. They give you a tax identification number, because just because you have a trust doesn't mean you're going to escape taxes. Okay, there's still a death tax. There could still be, if you're transferring property in and out of the trust, there could be transfer taxes, there could be excise taxes, just to let you know that part. So, okay, got the tax ID out of the way. You got the tax document. Okay, so I look over. Okay, it looks, your trust document shows you're going to put this checking account and this savings account into your trust. Okay, so you got to take your trust document along with an attorney certification letter. That's just a letter your attorney can draft up, and go to your banking institution and say, look, I want to take these accounts and put them in the name of my trust. You are the grantor, you created the trust, but you're also the beneficiary and you're the trustee at this time. So, and basically say, I want all my checks, all my accounts to say, trust of John Smith, okay, or the Smith Family Trust. What the bank is going to do is they're going to have forms for you to fill out. You're probably going to have to re-sign a couple things with your signature. Use your normal signature. They'll reissue you some probably new checks, and everything is going to be paid. So now everything that you pay out of that checking account is paid out of the trust, is out of that principal. So that takes care of that. But here's the other thing you want to do. These accounts that you've created, you may have without knowing, or you do know, you've made payable on death or transfer upon death accounts. You want to take all those names off because the trust is in control now. It's not you as the individual, it's you as the trustee. So the trust, remember, trusts can't die. Okay? Next thing. Retirement accounts, 401ks, 403bs, pensions. These get tricky, okay? And why I say that is because they're sitting over here in that account, in that 401k, 403b account, that pension. And now you want to move those into the trust. Seems easy, seems like it's no big deal, but it actually is. And I'm going to tell you why. Because if you take that primary and try to transfer it into the account, into your trust account, you're going to get whacked 100% on taxes, okay? because it's considered that you've withdrawn all of that money. So if you have $100,000 there sitting in that account, or let's say it's $1 million sitting in that account, and you withdraw it to go put in the trust, oh, your taxes are, let's not even talk about that, because we don't want that to happen. So here's how you get around that. On those 401ks, 403bs, you usually put a beneficiary that will receive the principal and everything that's in that account upon your demise. Name the trust, because now it's going to transfer to that trust after your passing. Let's talk about life insurance. Life insurance, very simple. Go to your life insurance policy company or go to your agent, say, hey, I want to make the trust a beneficiary. I want to take off my wife, my child, and make it the trust. Show them a copy of the trust document, attorney certification. They'll have forms for you to fill out, and that's it. You made that change. That's great. That's simple. You can also put cars in your trust account, which are kind of interesting because depending on the state, and I'm not 100% sure about the state of New Jersey, but I believe it, they can charge you a transfer fee and a transfer tax to transfer that motor vehicle into that trust. And so that's just something to look out for. Same thing with real estate and property. So when you're transferring, what you're going to need to do is either with your estate attorney or a real estate attorney, go to a title company and say, look, I want to transfer the deed that's in my name to this property to the trust that I own. They know how to do it. You're also going to want to contact your lender and say, look, this is my plan. Here's my title company. Actually, give the title company your lender's information and let the two of them converse. Because your title company's standards, they're going to tell you one thing. Your lender's probably going to tell you another thing. And you're going to go bonkers trying to figure out whose standards do I have to go towards. You want them to communicate. You want to make this as easy as possible. So you're going to go to the title company, you're going to go to the lender, and you're going to transfer the property. So there's going to be a transfer tax because you're taking it out of your name and putting it in the trust's name. And then you're going to have to sign a new deed. There may be a second closing, just so everything is done officially and then filed with the county clerk's office. So, one more thing, and this is important. You have children. We tend to have transferable to minor accounts. I'm just going to pull up the name really quick. I apologize. Uniform transfers or uniform gifts to minors. Excuse me. Wow, I'm having a brain fart today. I anticipated it, though. So, usually, these don't get transferred to the child until when the child is deemed considered the sole owner of the account. So to ensure that this, because it's a direct benefit to the child, the minor, you want to put a successor custodian on the account. Because you want to avoid, because you are the first, you're the custodian, and if you die and there's nobody there, then now the courts have to get involved, and you want to avoid that. So you appoint the successor custodian. I think I've covered everything. Yeah. So, with all that information at our fingertips, if you want to have a strategy session, 45-minute strategy session with me, contact me at njestateattorney.com. If you know somebody who's going through estate planning, may find this video helpful, have an issue with the trust, share this video with them. Tell them you were thinking about them. Give us a big like on Facebook, follow us on Facebook. If you're on YouTube, hit subscribe, give us a nice little thumbs up. Drop in the comment section, say hi. I love to talk. You know, my wife doesn't hear me enough every day, but hey, it's beside the point, and I just like to chit-chat, especially about estate planning. I love this stuff. As always, my name's David Campanile. I'm the owner of Campanile Law, located in the great state of New Jersey. We do estate planning and probate.